Welcome everyone to this explainer. Today we're unpacking a truly fascinating constitutional showdown. We're looking at the wild case of Wilhelm Geuking. This is a guy who found himself in the crosshairs of an international legal battle, and he attempted a massively high-stakes legal maneuver. He literally tried to use the absolute highest law of the land, the South African Constitution, as a shield to block his extradition to Germany. So let's dive right into this and see how a seemingly straightforward request for a fugitive turned into a total masterclass on international law, sovereign power, and fundamental human rights. To keep things off, I want you to consider this legal dilemma. Can a country just hand over one of its own citizens to a foreign government if there isn't actually a formal extradition agreement in place? I mean, most of us probably assume extradition requires a strict signed and sealed treaty between two nations, right? But what happens when that piece of paper just doesn't exist? Keep that question in mind because it's the exact spark that ignited this entire constitutional battle. Here is the agenda for today's explainer. 1. A fugitive in South Africa. 2. The extradition relay race. 3. Attacking the president. 4. The foreign certificate problem. And 5. The final constitutional verdict. Section 1. A fugitive in South Africa. The escape of Wilhelm Geuking.
So we first need to understand exactly who Wilhelm Geuking is, and why on earth he thought he had successfully outrun his criminal past. Back in December 1990, a court in Germany convicted him of fraud and arson. They sentenced him to 2 years and 9 months in prison. Well, he lost his appeal in 1991 and immediately fled to South Africa. By 1992, he actually managed to get permanent residence and citizenship in the former Ciskei. Then, fast forward to July 1995, he took what he probably thought was his ultimate insurance policy. He became a naturalized South African citizen. He completely ceased to be a German citizen. So when Germany came knocking in 1996 with a formal request to extradite him, Geuking truly believed his brand new passport made him untouchable.
But here's where he miscalculated. See, South Africa didn't actually have an extradition treaty with Germany. However, under Section 3.2 of the South African Extradition Act, the country can rely on a principle known as comity. Now, comity is essentially just friendly reciprocity. Think about it. Governments absolutely do not want their nations to be seen as safe havens for the criminals of the world. So even without a formal treaty, they cooperate with friendly states. Germany even noted they'd be more than happy to do the exact same for South Africa in the future.
Section 2. The extradition relay race. The mechanics of surrender.
Okay, to really grasp Geuking's legal attacks, we have to understand the actual mechanics of surrender. It helps to think of extradition not as a single, isolated event, but as a highly bureaucratic three-part relay race between the executive and judicial branches. Step 1. The president must give written consent just to start the race. Step 2. A magistrate holds an inquiry. This is basically the legal hurdle to see if the person is even eligible to be extradited. And finally, Step 3. The Minister of Justice takes the baton for the final leg and makes the ultimate discretionary decision on whether to actually surrender the person. During that second step, the magistrate's hurdle, they have a very specific checklist. One major thing they must verify is whether the crime is an extraditable offense. This relies on the principle of double criminality. Basically, the conduct has to be punishable by 6 or more months of imprisonment in both the foreign state and in South Africa. The magistrate isn't just looking at the name of the crime. They're looking at whether the actual conduct would be considered a serious crime locally.
Section 3. Attacking the President. Geucking's first constitutional challenge.
Now, armed with top-tier lawyers, Geuking didn't just sit around and wait for the finish line. He went entirely on the offensive. His strategy? Invalidate the very first leg of the relay race. Because, hey, if the president's consent was invalid, the whole race gets canceled. His legal team launched 3 distinct arguments. First, they argued the Extradition Act says the president's consent is required, but it doesn't explicitly give him the power to consent. Second, they pointed out Germany's paperwork was flawed. It listed Geuking as a German citizen when he was now clearly South African. And third, and this was their most powerful swing, they argued that agreeing to extradite a South African directly violates Section 21(3) of the Constitution, which guarantees every citizen the right to remain in the Republic.
But the Constitutional Court saw things very differently. Justice Goldstone, leaning on leading international authorities like M. Sharif Bassioni, explained that the president's consent is fundamentally a policy decision based on foreign affairs. It's a sovereign act. You see, the president isn't adjudicating guilt here. He's making a high-level diplomatic choice. And because South Africa generally doesn't prosecute its citizens for crimes committed abroad, the president is totally entitled to adopt a policy of extraditing citizens so their crimes don't just go unpunished. As for that wrong citizenship on the form, It simply wasn't a relevant factor to the president's diplomatic policy decision.
And what about that right to remain in the Republic? Well, the court entirely dismantled that argument by looking back at our relay race. The president's consent only triggers the process. It doesn't finalize the extradition, and it certainly doesn't physically remove the person from the country. Therefore, Geuking's constitutional right to remain in South Africa just wasn't actually being violated at this early trigger stage.
Section 4. The Foreign Certificate Problem. The Section 10-2 Controversy.
Since he couldn't stop the race at Step 1, Geuking took aim at Step 2. And this part of the explainer really highlights a fascinating friction in international law. Section 10-2 essentially forces a South African magistrate to accept a certificate from a foreign prosecuting authority as conclusive proof that they have sufficient evidence to prosecute. So I have to ask you, should a domestic judge really be forced by a statute to just blindly take a foreign official's word as absolute truth without even seeing the evidence themselves?
To see how this tension builds, let's compare the two responsibilities. A South African magistrate checks things that are locally verifiable, right? Like, is this the right guy? Has the president consented? Does this conduct violate South African law? But the foreign certificate does one very specific thing. It proves there is sufficient evidence to warrant prosecution under foreign law. Geuking's lawyers argued this conclusive proof rule was a massive constitutional violation. They launched 4 major attacks. 1, they claimed it robbed him of a fair public hearing because the magistrate's hands were literally tied. 2, they claimed it violated his absolute right to a fair trial. 3, they argued it deprived him of freedom without just cause. And finally, they argued it invaded judicial independence by letting the legislature basically blindfold a judge and force them to accept a foreign document. Pretty heavy accusations, right?
Section 5. The final constitutional verdict. Justice Goldstone's smackdown.
Well, Justice Goldstone and the Constitutional Court systematically broke down every single one of these sweeping claims. Let's look at the fair trial argument first. The court was incredibly clear here. An extradition inquiry is absolutely not a criminal trial. It's a completely unique proceeding. The person facing extradition is not an accused person in the eyes of the domestic court, and the magistrate isn't deciding guilt or innocence. Because of that, the strict fair trial rights under Section 35 simply do not apply to this step. The actual trial? Well, that happens in Germany.
Okay, but what about the deprivation of freedom? Remember our relay race analogy? The court pointed out that the magistrate only determines if the person is extraditable. The actual deprivation of freedom, the physical removal, happens when the minister makes the final choice to surrender. And the minister has massive discretion. They can refuse extradition if it's trivial, unjust, or if they suspect prejudice based on race, religion, or political opinion. So the system actually has built-in safety valves.
Now, what about the claim that this certificate strips away judicial independence? The court gave a wonderfully practical answer to this one. The certificate only answers one very narrow question. Does the evidence warrant a prosecution under German law? South African judges and lawyers are not experts in German law. It is completely reasonable and totally not a threat to judicial independence for the law to rely on a foreign expert's conclusive opinion regarding their own country's unique legal standards. Ultimately, Justice Goldstone delivered this final verdict, stating, "The conclusive character does not detract from the fact that the magistrate's inquiry is sufficient to meet the constitutional requirement of just cause." So, Geuking completely lost his appeal. The procedures in the Extradition Act were upheld as entirely constitutional, perfectly balancing international cooperation with domestic procedural fairness.
As we wrap up this explainer, I really want to leave you with this final thought. We live in a world where criminals can easily cross borders thanks to modern technology. If extradition is fundamentally a sovereign act of foreign policy, a tool to ensure the world doesn't just become a patchwork of safe havens, where exactly should we draw the line between global comedy and our own domestic constitutional rights? It's a remarkably delicate balance, and as this case shows, the courts have to navigate it with incredible precision. Thank you so much for joining me to unpack this fascinating legal journey. Keep questioning, keep learning, and I'll catch you in the next one.